We now look at how marriage affects a person's capacity to contract. In this regard, it is important to note that there are different types of marriages. The first being married in community of property. That basically means that you share joint, undivided estate that is made up of your respective assets and liabilities, including those that you accrued prior to the date of your marriage. You can also be married out of community of property. This means that there is no joining of estates and each spouse keeps his or her estate separate. However, the spouses can choose to either include or exclude the accrual system from their antenuptial contract. Let us look at marital power in more detail. Previously, the law provided that the husband was automatically the sole administrator of the joint estate, and he alone had the capacity to bind the joint estate. This meant that the wife was virtually in a position of a minor and required her husband's consent to ratify contracts that bound the joint estate. This situation changed for marriages entered into on or after 1 November 1984 with the introduction of the Matrimonial Property Act. Under the Act, marital power is automatically excluded and women and men have the same contractual capacity. Marriages are automatically deemed to be in community of property and in community of profit and loss. The wife is a joint administrator of the joint estate. The spouses are regarded as having equal rights and duties. Neither spouse may dispose of certain assets without the written consent of the other. If a spouse does so to the disadvantage of the other, the prejudiced spouse may be compensated on the dissolution or termination of the marriage. Then, in 1993, marital power was abolished in South Africa with retrospective effect. Marriages may now be completed in one of two ways. A marriage will automatically be in community of property unless the parties enter into a property executed and registered antenuptial contract before the marriage, in which they specifically exclude community of property and community of profit and loss. However, if you are married in community of property, formal consent is required to alienate or mortgage from the joint estate a real right to immovable property, purchase residential land in installments, enter into a credit agreement as a consumer, or bind themselves as sureties. That is written consent. Generally, the act will be void unless the necessary consent has been given. If, however, spouses sign an antenuptial contract before the marriage, they may be choose to married out of community of property. They both have full contractual capacity and are not liable for each other's debts. However, they are jointly and severally liable to others in respect of any debts each of them may incur for the joint household. Parties may also choose to marry with the accrual. In terms of the accrual system, a commencement value of the estate of each spouse is agreed upon at the beginning of the marriage. On dissolution of the marriage, the final value of each estate is calculated. The difference in growth between the two estates is divided and shared equally between the parties. The right to the accrual arises only on dissolution of the marriage by death, divorce, or court order. However, the following assets are excluded from the accrual: inheritance, legacies, and donations. The antenuptial contract must be duly initialed and signed in duplicate, original, by both parties and two witnesses, and by parents or guardians where assistance is needed, and will be attested before a notary. The antenuptial contract must be registered in the deeds office within 3 months of the date of signature, failing which it will be registered late only by application for a court order. If the accrual system has been specifically excluded, each party, or his or her estate, retains his or her own property without any claim against the other, or the estate of the other, if the marriage is dissolved either by death or divorce. Each spouse retains control over his or her own estate and can perform legal acts with regard to that estate without the consent of the other spouse. The next element in order for a valid contract to come into existence is that it must be certain and definite. The contract must not be so vague that the court is unable to work out what it means or what the intention of the parties to the contract are. Categories of uncertainty include vague and indefinite language, failure to agree on mutual provisions, granting to a party of unlimited choice whether to perform or not. For example, payment of the purchase price in monthly installments, free of interest, has been held to be too vague because the buyer alone decides the amount to be paid every month. Agreement to agree. A contract to enter into another contract may not be valid if it has an indefinite duration and if it has an external mechanism to create certainty. For example, an escalation clause in a lease agreement to determine the extent of rent increase may state that the rent will increase automatically each year by CPI plus 1%. Similarly, that a party may use its discretion to decide the extent of one party's performance. Such a clause may be valid provided that the identity of the third party is identifiable and that the discretion is exercised objectively and reasonably. Next, the contract must be lawful. The principle of sanctity of contract, also known as pacta sunt servanda, means that agreements reached between people should be recognized as binding and enforced by the courts. However, our courts also recognize that some agreements are contrary to law or morality, or are against social or economic values, and therefore should not be enforced on the grounds of public policy. In determining public policy, courts have recognized the interests of society and the community as a whole. Contracts that are entered into freely should generally be enforced. Parties to a contract should have the same bargaining power. The contract should not interfere with the administration of justice. The public service should be allowed to run properly. The legal rights of people should not be interfered with. For example, you cannot enter into agreement with someone to kill another person on your behalf, as it would not be lawful to do so. However, statutory prohibition or illegality does not always render a contract void. In each case, the court will examine the facts to determine whether it was the intention of legislature to render the agreement void.